audiences. I've spoken in front of your audience before, and it's been fantastic. And it's going to be, again, fantastic today. Thank you so much for having me on with you today. So my name is Sam Price. I live and work in Redlands, California. And I have my wife and our little 8-year-old son. I have a practice that practices my law practice is just in probate. So I only do probate, estate planning, and trust administration. So people ask me, how do you do a bankruptcy? How do you do a divorce? How do you defend a DUI? I don't know. I only do probate stuff. So in my practice, one of the things that I have to do is I have to be reminded that I have to work with folks with compassion and empathy, because people come to me with a problem that cannot solve on their own. And they come to me at a very dark time in their life when they've lost a loved one. And so from our office's standpoint, we work as a team. We be able to work with our clients and be able to treat them with dignity and respect, and have that empathy and compassion that they need in this time of need. And so for our practice, I'm a certified specialist in estate planning, trust, and probate law. And so really, I'm there to guide folks through the probate process. And if I could just take a second to explain what probate is.
Please.
So when someone passes away, they own stuff. They have a house, a bank account, a car. They have the contents of their home, furniture and furnishings, and they have other stocks, bonds, mutual funds. They have assets. And when someone passes away, there has to be either some type of process that transfers that asset to the new person that's supposed to receive it, or there has to be a court that appoints one person, an executor, an administrator, that has the power to be able to manage those assets, sell what needs to be sold, pay the bills, and then distribute the remaining assets to who's supposed to receive it. So probate is that court process, the court process that either transfers assets or appoints someone to be able to manage those assets. And that's what we help folks with.
Well, even with that, how does someone decide who's going to be appointed, especially when you have 4 or 5 siblings? How do you decide that?
So here's the most common scenario. Mom or dad dies, and they have adult children. And I say children because the probate code calls it a parent and child, but these children are adults. They're not youngins, but they have a need to be able to figure out what to do with mom's house. And there needs to be someone in charge or to distribute the house to all of them. So either one of them they need to pick someone amongst them, or decide that they all receive it together. Now, if there's 5 or 6 of them, hard to get 5 or 6 people to agree. Sometimes they go in birth order. Okay, I'm the oldest, I'll take care of it. Or sometimes it goes with the most responsible person. Or sometimes some folks have something going on in their life that it's not really right for them to be that executor or administrator to manage the estate. So somehow they have to pick amongst themselves who should be doing that.
Right. And someone brought up something today. They mentioned this word, and I don't know if this would be probate or how this would work. Common law marriage.
Yeah.
Is that a
It's
thing?
oh man, it is not in California, but there is a thing.
Okay.
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 So we're so familiar with understanding that if the couple live together, this is a romantic couple, even if they don't get married in a common law state, they can be common law marriage after a number of years living together. Usually it's about 7 years. Now, California is not a common law state. California is a community property state in which either you're married or you're not, because you have to choose to become a part of the community, which is the community property. And so that in California, you have to be married. But there is this case. Have you heard of this case, Marvin versus Marvin? Are you familiar with this
I'm
case?
not.
It's okay. It's okay. I'm going to tell you that Lee Marvin was a Hollywood actor he had big hits in the 60s. In fact, he won a best actor Oscar for a movie called Cat Ballou. He was in it with Jane Fonda, and he played 2 characters in that movie. So he had this a lady who he was together with. They were a romantic couple. They did not marry, but she changed her last name to Marvin. Her name was Michelle Marvin. And when Lee Marvin and Michelle Marvin got together, they had an oral agreement, not even a written agreement. They orally agreed that Michelle would give up her career. She was a B movie actress. She sang, she produced small stuff, but he was a leading actor. And they agreed that she would give up her career so they could have a life together and socialize. And when they broke up, the court case where she sued Lee Marvin went all the way to the California Supreme Court. And the California Supreme Court said that even though there's no common law marriage in California, even though they never married, because they had an agreement that they would share everything together, that she gained a half interest in his stuff.
Wow.
And so that's a huge case for folks that, although there's no common law marriage, they live together. That's a requirement. They live together and are a romantic couple. So it's not for roommates that aren't together, but this is for romantic couples. And so there is such a thing as Marvin versus Marvin relationships, and we call them Marvin relationships after this case from Lee Marvin and Michelle Marvin. As just as an aside, later on, Michelle Marvin got together with Dick Van Dyke. So she was with another famous actor as well later on.
Okay.
She's
wow,
since
hopefully
passed.
she got it right.
Yeah, no, she's since passed away. Yeah.
Oh, okay.
That's right.
Okay.
Yeah.
So in that kind of situation, I had a situation where I got a call from a lady who her boyfriend passed away. And she was like, well, I paid the bills and he's estranged from his son. His son wants to now come in and get the property. In that scenario, is that something that I'll say, okay, here, you need to call Sam because well, they will call you anyway, whomever, but would that be considered a probate? Like who would have that choice? How does that work?
Yeah, so there's a hierarchy of who has priority to be appointed as an executor or administrator of an estate. And so the first person that has that choice is the spouse. But see, they didn't, in your scenario, they didn't marry. The second person is a child. Now, estranged, that happens in life. Everyone's got a weird family. I have a weird one too. So everybody does have their quirkiness to their families. And I'll tell you that even if someone is estranged, they are still under the California law entitled to be the executor or administrator or receive their share. Now, again, if they're if it's boyfriend and girlfriend and they live together, there's no common law marriage, but there might be a Marvin claim there that is available to her. If the facts fit her case, they may or may not fit her case. If they didn't have an agreement to divide everything up or split everything, then that would be a problem. But if they live together and she paid bills and put down money on the house, she may have a claim. So that's something to talk out with an attorney, that if whether or not she might have a claim under Marvin to be able to claim half of the assets. But the son still is entitled to share, even though he's estranged, because it is that if it's a natural child, that relationship has been established.
Okay. These questions are just coming to me because I get all these scenarios that happen and I'm like, what happens? Because I said, I'm not an attorney, but I don't know anything about common law. She's like, I pay the bills and he doesn't. I'm like, I don't know. I'm not the attorney. She said, I knew I should have just lied and told them I was his wife. I said, I think you have to prove it too.
Yeah, they want to see a marriage certificate. There has to be some paperwork. There's a paperwork involved in that. Yeah.
I think so. All right.
It can't be just, we went to the local witch doctor and we had a ceremony. Right. That's not enough. You need some paperwork. Yeah.
You need the proof.
That's right.
Proof. All right, so let's talk now a little bit about the probate process. So you have the 6-step probate process. Please share.
Yeah, so there's the most common type of probate is what I call a formal probate. So this is one in which the court is going to appoint someone to be the executor or administrator of the estate. And the only difference is executor, there's a will that names that person. Administrator means there's no will. And so the first thing that we're going to do is in step 1 is we're going to assess, gather information and documents, figure out what's going to be the game plan for this probate case. I draft a petition and the client signs it. And once I file it with the court, we're going to move on to stage 2. And in stage 2, the court has set a hearing date. I go to the court hearing. My client doesn't have to go. But in the meantime, I have to publish in the newspaper to give notice to potential creditors, and I have to be able to mail out notification to anyone who's entitled to it. The court might have some questions for us that I can answer in a writing to supplement the petition we filed. And then we're probably going to have to get what's called a probate bond. And a probate bond is sort of like an insurance policy, except it's different. It's where if any of the money is mishandled of the probate case, then there's a payment source there. And that's what a bond company is there for. And so many of my clients will have to serve with what's called a probate bond because they're handling money that's not theirs. It's the estate's money. And potentially maybe their siblings also might be entitled to some of this money. So at the court hearing, I'm expecting the court to approve the petition. And then my client gets appointed as the executor or administrator. And then we're off to the races, whether we're looking to what I find if we have like 5 or 6 different children. Mom has passed away, 5 or 6 brothers and sisters that that are all entitled to 1/5 or each. Let's say there's 5 of them. What I find is that no one wants 1/5 of a house that you don't live in. They just want the money. And so a lot of times, maybe one of the siblings lives in the house. Maybe all 5 of them, none of them live there, and they just want to sell the house. So that's where, a lot of times I, as a probate attorney, I don't sell houses. But I need a realtor to come and help us to get the house sold because realtors come and sell houses. And so we work with a realtor to list the house for sale, get it in the multiple listing service, widely marketed for sale, maybe some open houses. And then the executor picks one of the offers, signs it. And now I do some paperwork so we can get the property sold. The house is sold. And now we converted a house to cash. And we put that cash in a special bank account for the estate. And a lot of times, mom lived in California, but my personal representative, the executor, lives in another state. But this account has to be opened in California. It's required. It has to be at the California branch. So we could help clients with that. And so we've sold the house. Maybe there's a car. It's California, so everybody's got a car, right? So we got to sell the car too. Sometimes if someone wants the car, that's cool. You could keep the car if you want to keep it. That's part of your inheritance is the car. Maybe mom had a bank account, so we've got to gather the funds from the bank account. And that's the majority of all assets is a house, a car, a bank account, and then the stuff inside the house. And sometimes it's worth stuff and sometimes it's not. And sometimes there's sentimental items, photo albums and pictures and costume jewelry that people want. But most of the time it's not. I mean, when I'm gone, my stuff is junk. I tell you, they're going to trash out my house because my house is just full of junk. Yeah. It's not worth anything. But once we've done gathering up all the assets, we got to pay all the bills. So whoever paid for the funeral costs, they're entitled to be paid back because that's an expense of the estate. Maybe mom had some hospital bills or last ambulance ride. Maybe she had a credit card. Those bills have to be paid. So we have to look to see who the creditors might be. Maybe mom had Medi-Cal benefits and Medi-Cal has to be paid back. So there's certain things in a probate case that we have to think about. The biggest one that a lot of clients, it's not on the radar, is the income taxes. So, if someone passes away in the middle of the year, they haven't filed the tax return for that year. So here it is in 2025. Today is July 7th. You die today, July 7th. You owe a tax return from January 1st to July 7th.
Wow.
Yeah. So if you had income and someone's got to pay income taxes on that. Now it's July. Some people have filed an extension for their 2024 tax return.
Right.
And if you filed an extension, well, you haven't filed the 2024 income tax return. So that one is due too. So we have to catch up all the income tax returns because whoever receives the assets of someone's estate is liable for the income taxes that were owed. And if we don't have an income tax return filed, the IRS has no statute of limitations to go back and request to be paid for and interest and penalties are racking up that make it astronomically expensive. So we have to make sure that income taxes get taken care of.
Okay, hold that thought. We have a
Yeah.
question on Facebook. And by the way, those that
Okay.
are watching, I'm on my computer. I'm looking down at my phone. I'm not doing anything else but checking out my folks. So my friend Nicole is on, who's just invited a ton of people on. And thank you so much, Nicole. Her question is, why do the bills have to be paid if they're deceased?
Yeah, you know what? You think that the bills stop when you die, but they don't. You still owe the money, right? There's two types of bills. So I want to make clear what types of bills there are. One is bills the decedent owed before death. So that's again ambulance ride, last ambulance ride to the hospital, hospital bills, credit cards. Those are the most common type of bills. You even had your utilities that you had to pay, right? Your electric bill, your gas bill, the water bill. So before you pass away, you owed some money. There's money you owed there. There's one time, and those are called creditor claims. Creditor claims are bills the decedent owed, and they don't go away just because you die. There's one type of creditor claim that happens after you pass away, funeral expenses. So if you have funeral expenses, those are also called a creditor claim that have to be paid from the estate. So first is creditor claims. The second type of expenses are called administrative expenses. And administrative expenses is during a probate case. So it's everything after death, except for the funeral expenses. Everything after death. So it is the court costs, newspaper publications, appraising assets. It's the carrying costs of the real estate, property taxes, insurance, utilities, repairs and maintenance. It is the attorney's fees for the probate case. It is the expenses that we have to have for the probate case, but it's also the executor is entitled to the same fee an attorney is. So they are entitled to be paid. All those administrative expenses are likewise going to be paid out of the probate case. And so those bills continue on, and those are two different types, before death and after death, that have to be paid from all the assets of the probate case.
Thank you so much. Hopefully that answered your question. The income tax, I guess I'm still kind of stuck on. I'm so glad you said that because we don't think about that. And um, I, how does that work? So if someone passes away, let's just say they ended up with a W-2 that the family never got. For example, one of the probates that I just closed, the tenants in the property was not giving all the stuff over to the people, so we don't know where the stuff is. We don't know everything that's happening. I have thoughts of how you can retain it, but I'm going to let you share that of what that looks like for them to get that information and check and do their due diligence to make sure taxes are filed.
So a lot of times with tax returns, what we do is we go to number one, ask the IRS. You can ask them for a transcript of prior tax returns so that you know what was filed previously. Kind of gives you a clue of what to file this year, but they can also give you any types of the 1099s, the W-2s, those types of things, that the 1098s, those are interest, those types of things that get filed with the IRS. They'll give them to you so that you can be able to file that tax return, because they're not trying to play hide the ball with you. They want you to be able to have the information you need to file those returns. And a lot of times what we do is we go to the decedent's old tax preparer, because they have a lot of this information and we'll kind of have an idea of where that income is. So if we have someone who's passed away, we're getting their bank statements that come in the mail, the brokerage statements. Those are going to give a clue as to where that income came in. If we have some old their employer, that we can get their pay stubs and we'll know what their income was. So those are clues that we can have, that we would have to be able to file that income tax return as best we can. Now, if we don't file an income tax return, the statute of limitation never begins to run. And so a lot of people will say, well, wait a minute, mom didn't make enough income to require an income tax return being filed. And I say, okay, that's cool. But my recommendation, and I always give the most conservative advice, is file an income tax return anyway, even if it's a bunch of zeros. And that's because that starts the statute of limitations running with the IRS, so that they have up to 3 years to audit the return. So they can't come back to you later and say, hey, where's that tax return? It also tells the IRS not to expect another tax return. It says, deceased, and it says the date of death when on the final tax return. So now they know the person's passed away, and they're not going to expect any more tax returns after that.
Wow, great information. Great,
Yeah.
great, great information. Um, yeah, she said that was good information. She said, "Wow, didn't realize that."
I
It makes sense.
know, I
So,
know. I thought
yeah,
I'm done. The bills are done. No, no.
right.
Oh man. Yeah.
Yeah, there's more to
Unfortunately.
come, right? More
That's
to
right.
come.
Yeah.
So,
But you
did you
know
go
what? But
through?
that part of the probate process is to determine what are valid claims and what are not. So there's a deadline. When you file a probate case and you go through the administration of a full probate matter, part of this is we're publishing in the newspaper for creditors. If we know of any creditors, right, we're getting the decedent's mail. If we know of any creditors, then we can notify them. And oftentimes, they don't file a creditor claim. No creditor
Mhm.
claim, you don't get paid. And so there's a deadline, 4 months from the time the court appoints you, with what are called letters, letters testamentary, with if there's a will. You got 4 months from that date to file a claim, and if you don't, you're not entitled to payment. So part of this is to cut off those creditor claims. I once had, oh man, you know what? I had this. My client, his mother passed away. She
Mhm.
had cancer. She had $3 million of hospital bills. So we did this process. They didn't never filed a claim. We notified them and everything. They never filed a claim.
Wow.
Yeah. So part of the process is determining what creditor claims there might be and cutting off their rights to make a claim.
Wow. Awesome. Just seeing if we have any other questions. All right, so you were going through each one. I
So
don't know if you got to six yet, but
yeah, I'll get through. I'm at 3. So
oh,
we're in
perfect.
stage 3. We're administering the estate. We are gathering up assets, selling, giving out to who is entitled to it, what they want. If they want something from the house, if you want some small things, personal, sentimental items from the house, go get them. We're selling the house. We're gathering up the bank account. We're selling the car. We're paying the bills. Once we've done all that administration, gathering assets, paying bills, filing taxes. Now we're ready to go on to move stage 4, where we're winding up the estate. I'm gathering information and documents about the administration. I'm drafting an accounting, and all an accounting is, it tells us what did we start with, what money came in, what money went out, and what's left over. And then I draft a petition. My client signs it. I file it with the court. That puts us in stage 5. In stage 5, we are getting that a final order. So I have to mail out notices. I have to attend a court hearing. And then once it's approved, I get an order. That court order to distribute all the assets, that puts me in stage 6. So now I can distribute. And so we're giving out the money to everyone, paying the cost, the attorney's fees, the executor's fees, reimbursing anyone who's paid money for the estate. And then we are distributing all the funds that everyone's entitled to. And then we're getting discharged and getting rid of the probate bond. There may be a final tax return for the estate. So we talked about the tax return for the person who passed away, and that's on their social security number with their 1040, the tax return that you and I file every year.
Mhm.
There's a different tax return for an estate with the estate's employer identification number. It's a different tax ID than the social security number. And so that there might be an income tax return due for the estate, especially if we sold the house or the car, there's going to be an income tax return due. And that is reported on form 1041. It's a different
Oh, wow.
tax return. So there's, at the end of the case, we might have to file one of these tax returns as well. So that is
Okay.
kind of the process of a probate case.
Wow. So it's it sounds so smooth.
Well, I just described a process that takes 1 year to a year and a half, a year to a
Yeah.
year and a half, something in that 12 to 6 to 18 months is how long that takes.
So when someone kind of going back to you talked about accounting. With the accounting, when you have the personal representative or administrator, uh,
Yes.
when they're taking care of the estate and they potentially might get something from it, do they need to keep track of phone calls, trips to the courts, whatever it is that they do? Are they supposed to keep like how does that work?
Well, an accounting is about money. So if they paid bills, so if they paid, for example, the property taxes and the insurance, and they want to be paid back for that money they paid, then they need to keep track of how much money they paid out.
Okay.
I keep track of, for my clients, the expenses to the court or appraisals or newspaper publication. I do the probate process, but there might be bills of the house itself, or it might be they had to re-register the car, or uh, pay utilities for the house. Those expenses that they want to be paid back for, they have to keep track of those. Now, if they want to be paid extra money, because they're entitled to be paid for being the executor. So
Hmm.
they're entitled to a fee just for being executor, a percentage. And I'm going to say the percentages, but don't worry about remembering these percentages. It's 4% of the first $100,000, 3% of the next $100,000, 2% up to $1 million, 1% up to $10 million. So if you have a $500,000 estate, that's 13,000. If you have $1 million estate, that's 23,000. So it's a percentage. Now, I, as an attorney, am entitled to that same payment. But the executor and I are both entitled to what are called extraordinary fees. So what those percentages I described, they're by statute and they're set by California law. Every attorney in the state of California charges the same amount. Every executor is entitled to the same amount. But you could be entitled to extra money called extraordinary fees. And so for that, if they want to keep track of the date, a description of what they did, how much time they spent, they can ask the court for additional money. So it could be a lot of things. It could be they cleaned out the house, or they had to go down and deal with the tax assessor on some property taxes for the house. It could be that they had to spend extra time with the insurance agent dealing with, or a lot of time, it took a lot of time to sell the house because of the condition or something like that. They could keep track of those things and ask the court for additional fees on top of those percentages I mentioned.
Okay. Awesome. Awesome. I'll tell you guys, it's a lot that goes into this. I got like 50 million questions, but I'm not going to ask any too much more. I wanted to bring Sam on here because I think it's important just to be educated. I'm not saying you have to know all of this up front. Trust me, it's important to make sure you have the right person that comes with you and walks you through the process. So, with that said, this was a question that was brought up to us in our meeting, and I'm going to bring this up. I have my answer because I feel like this should be a no-brainer in a sense. But some people like to do the probate on their own, and they don't want to go to an attorney because of the fees that are involved, and they feel it's better to go through it on their own. What are your thoughts in regards to that? What do you tell people?
Well, it's supposed to be something that people can do on their own, but in reality, it's super difficult to. And even attorneys in other practice areas try to come into probate. That's why I stay in my lane. I only do probate because it's something that is very complex and involved. And even other attorneys that don't know probate try to do probate matters and then find out it's a completely different world. And so, what I would say about that is that the easiest part of a probate case is getting appointed, but administering an estate, doing an accounting, doing a final petition, that is the hardest part. So a lot of times, some people will try to go to a paralegal or a legal document preparer, and they might be able to get them part of the way, but not the entire way, because that's not a person that does only probate. They do family law and bankruptcy and civil litigation and small claims, and they do all kinds of things, but they don't exclusively do probate. And so what I would say is that if you wouldn't necessarily want to sell a house on your own, because there's so much more involved, that because some people try to do a for sale by owner
Mhm.
when they sell a home. But you and I know that there's a lot more that a broker does than just put a house in the MLS.
Right.
There's so much paperwork to it and know-how of how to fill everything out, and how to manage the transaction. That's the same thing with probate, because for a year to a year and a half, you are getting not only the paperwork and someone appearing in court for you, but you're getting the legal advice of what is needed to guide you through that probate case. And when you appear in court, the judge cannot give you legal advice. A paralegal cannot give you legal advice. You can only get that from an attorney. And so, to really be able to get things done the right way, you want to go to a professional. And yes, there's a cost to it. But that is absorbed not by my client, but rather by the estate itself. So you want to have a professional involved with your matter.
Awesome. I really wanted you to answer that question because there are these intricate details that can arise. And I'll tell you, before I met Sam, I had a client that we closed a deal with a couple of months ago. She ended up with an attorney later, but we had to go through so many attorneys. Everybody kept denying her, but even the courts are like, you should get an attorney. But it was just so hard because it was a tough. I can't even get into the details of what happened. Matter of fact, I said I'm gonna do a whole just talk about it once we get this thing closed up because we're still not there. But it is important to find that professional. Like people say, well, I can buy a house on my own. Can you? What happens when that lender messes up or doesn't call you or they forget to tell you what they did not do? Who's there to defend you? What happened when that
That's right.
seller didn't disclose something, even with this for sale by owners? I'm like, you have to disclose everything. So if something goes out today or in the middle of the contract, you can't just patch it up and not say anything. Like
That's
this
right.
stuff comes back to you. So you want to keep those things in mind. Professionals are here for a reason. Everybody wants to save a buck, but it'll cost them two later. So, or 5 or 10 later. So that's why I think it's important. Okay, this is my last question.
If I
Anybody
could,
that's on? Oh, yes,
if
please.
I could mention one last thing,
Please.
when it comes to doing things on your own, you're not going to get any legal advice. So you're going to go up to this court hearing, you're going to stand in front of a judge, and if your paperwork isn't right and tight, your court hearing is going to get continued. And the continuances are
Oh
3
my
to 5 months
gosh.
out. And so if you think about if you've delayed your case 3 to 5 months because something's wrong with your paperwork, it's going to cost you more money in that delay than had you hired an attorney to do it the right way the first time.
Yep.
And so time is money. And when you've got a house to carry and there's costs and fees of this house every month that are racking up, those continuances that you get because you're not doing your paperwork right and tight is going to cost more than had you hired an attorney.
And I will tell you, we are the this particular probate had 2 administrators. One was kicked off by the judge because he decided to fire his attorney in the middle of the deal. It was just a mess. So anyway, my client ended up taking over and he was supposed to do his accounting, I believe May or June of last year. And it was always something. He got sick. This happened, that happened. And I think he's had so far at least 5 continuances. And we go to court again July 24th, where the judge said that if your accounting, because he looked at the accounting and he said, who did this? He said, I don't
Right.
have no idea what this is saying. Get an attorney. And the
Yes.
guy tried to explain. He said, I don't understand this. Get an attorney. So he said, okay, we don't know if we've gotten an attorney. He hasn't uploaded or changed anything as of yet, but he told him clear his notes or you're getting a $1,500 fine. So this has been
Yeah.
going on and we can't do I keep saying we, because I've been in it so thick. My client can't even do her final accounting until his stuff is clear. So
Yeah.
I don't know what just
Correct.
happened. Did something just shut off? No. Okay. Something just happened with my computer. Anyway, so yeah, it's a lot. And if you don't have the right person on your side or have someone fighting for you, then you're going to be dealing with things for probably more than a year and a half. So it's a lot. Okay, this is my
And
last question. Yes.
what I want to do before your last question, you
Yeah,
killed
yeah.
my question, but you know what?
Yep.
There's a new probate process, and I want to take a minute to talk about it because there's this new process that allows us to be able to transfer. This is different from what I just described.
Mhm.
Transfer a primary residence that's valued up to $750,000. This is only for someone who dies on or after April 1st, 2025. So if you died before that, a different amount applies. But if we have a case in which someone wants to transfer primary residence and maybe some money up to $208,850, we can get this through without the year to a year and a half time frame. But it's slightly different. Number one, there's no administration of the estate. So that what that means is there's not this process to see what bills that the decedent owed. And when we don't do that and go through the creditor claim process, everyone takes the bills. So if you receive the house through this process, it's called a petition to determine succession to primary residence. And that process means that if mom died and had 5 kids, all 5 kids go on title to the house after this process. All 5 will own it. There's not one person put in charge.
Okay, so let's back up
Okay.
because that was actually my question was about that bill. So you dived right in.
Okay. Oh,
Perfect.
right. We're talking
Yeah,
about the same
that
thing.
was the
You and I are on the
question.
same page. Okay.
Yeah. So my client just did that literally today. She gave me the information. She filed today. We have court August. I keep saying we. I feel like I'm in the middle. I'm
Yeah, you
within
are.
right.
No, you are. You're part of it. Yeah, you were a little.
We have a court date August 13th at 8:30. So are you saying that once they go to court, the three siblings will be now put on title? So now they have to
Yes.
sign, each one got to sign one,
Yeah.
something?
So all five have to sign that petition. They all have to participate. Notice must
Wow.
be given, delivered within 5 business days of filing the petition. And at the court hearing, you have to prove why that was the primary residence. Usually it's easy. We look at the death certificate, it says usual residence. For most people, I'm a normal person. I got one house, right? I don't have more than one house where I have to like, oh, which house do you live in, Sam? No,
Right.
no, I've got one. So
Okay.
most people, it's simple that it's their primary residence. That's the place where they live.
Mm.
But if you have a primary residence and other property, this isn't going to work because you need now a formal probate case. If you have 5 people that are supposed to go on title to the house and they don't get along, you're going to have some problems. And so
Wow.
you need to be able to understand that there are benefits and burdens to this, pros and cons, good and bad to doing this. You're going to get the house faster, but you have to have, it's going to take longer because you have to get an inventory and appraisal. You have to file a petition. The court sets a hearing date. There's no priority to be for the court to have this type of case heard in a certain amount of time, like there is for a formal probate that's required to be heard. It's within 30 days. But oftentimes we're talking about 30 to 45 days. But that's not true of these other types of petitions. So it could be much longer that the court has the time frame. And if we're trying to sell the house fast, if some people are contributing the bills and some people aren't, how do you get contribution from them? Because when escrow closes, each one is we're entitled to 1/5 if there's 5 of them. So
Well,
these are things to work out.
well, the good thing, well, what I know so far, they've done the appraisal's been done.
Good.
The notice have been given. Everybody's amicable. So far, so good. So I guess whatever they're going to on August 13th, because this is fresh and new. That's why I want to be involved with it. That is supposed to determine the final, I guess, of yes, this is good to go and they should be able to go, which August 13th is about 35 days, 37 days or so from today.
Yeah.
So yeah, wow, those are things we got to think about, you guys.
If your paperwork is right and tight, you'll get an order that day, get a certified copy, record it with the county recorder, and the 5 of them own the house. Now all 5 of them have to sign the listing agreement, have to sign the agreement, have to sign the deed.
Wow.
All 5 of them will own the property together.
Okay. That's, you know what? Wow. Okay. So that's something I'm going to share with my client because that's why I said, do they understand the process? I don't know if they knew that everyone else had to. And with this being so fresh,
all 5 have to sign it.
Right. And it's only, well, it's 3 of them. It's just 3.
Oh, 3. Okay. Sorry. 3. Yeah.
No, it's okay. So that's good to know because it is fresh and new for many realtors. I went on mute somehow.
You're there. No, I hear you.
We have to be careful giving legal advice. Now, I'm not going to even air quote that one. Giving legal advice to people because they have to think about everything that's involved. Because what if somebody decides, you know what, I don't want to fill it out. I don't want to sign. And we know
one person isn't signed, you can't do that. If one person is a minor, right? I mean, sometimes you have adults over 18, but one person's under 18. No, you can't do that process. Someone is under conservatorship, the conservator has to sign it. So there's requirements to be able to do this the right way. If you have a large family, I've had cases where there's like 20 to 30 different people receive. I'm not going to get 20 to 30 people to sign my paperwork. At that point, we just appoint one person to be in charge. If people don't get along, then you need to not do this process. If one person wants to keep the house, the other person wants to sell it, and there's not some agreement that person buys it from the other, again, problems. So, and there's differences in the, if everyone receives the property, there's no sibling exclusion for property taxes. Property taxes is again something that's not on people's radar. So there's a parent-child exclusion. So if we receive the house from the estate and we live there, there can be a parent-child exclusion, but if someone doesn't live there, there's no exclusion for that person.
So like there is a child that lives in the property right now, adult child that
One of
lives
the
in the
three.
property. Would her
So
portion,
one third
one
is
third of
entitled.
it to the, wow, and everybody else has to pay taxes on potentially.
Property taxes go up. And so
Okay.
who pays that? Right. So the person that lives there, like, hey, my property taxes stay the same. That's your bill because you don't live here. And so are they going to be able to get that money from those people on
Oh
the
my
supplemental
gosh.
property tax bill?
Yeah,
These
I
are
gotta
this
make a phone call.
consideration. Just let you know. Just
Yeah, I'm sitting here,
Sam
sorry, my
says.
body's heating up like,
That's
oh
right.
shoot. Um, yeah, wow. So this is good to know, good information because they need to understand again the power of professionalism. There's a lot of people that feel like they can do this on their own. They don't need to hear from anybody. It's just, let's just do it our way because they're trying to save a buck and it costs them more later. There's a question. One person should wait.
Yeah.
Okay, she's responding, Sister Annie. One person should be identified as the heir, right? So she was asking with that particular process, one person should be identified as an heir.
So if we go through a formal probate, one person is going to be that executor or administrator, the person that handles the whole estate. So if we have mom dies and then there's three kids, one of the three kids gets appointed. That's a formal probate. And that's the most common type. If we want to give the property to all the heirs, all three of them would receive the property. So if mom had two sons and a daughter, then the two sons and the daughter would receive the property, one third
Okay.
each. I hope that
Okay.
answers that question.
If it didn't, just let us know. We're going to start wrapping up, and if I see any more questions, we'll move on. But I'm excited for this. Thank you so much, Sam. We talked about a part two. We're
Yeah.
actually, oh, it said she said for receiving parent-child tax benefits.
Well, the requirement is that of course, it had to be the primary residence of the decedent, and they had to have filed for a homeowner's exemption with the county assessor. And then whatever the child is receiving the property, you must live there and you must file a homeowner's exemption within a year of the death. So if you don't do that, you won't qualify for the parent-child exclusion. It's not enough to be the child of this decedent. You have to have lived, must live at the property.
Wow. And this
Yeah.
is for the new
Prop
bill, or is
19.
this for,
This is
oh,
for
this is for Prop
this is for
19.
residential real estate. It only parent-child exclusion only works for
Right.
residential real estate. It's not commercial or vacant land, it has to be a house. Someone has to
Okay.
live there. Yeah.
Okay. Okay. All right. Awesome. All right. Well, what we're doing is, like I said, I'm excited because we are going to have Sam back, but we're going to be talking about a little bit more about estate planning. And I
Sure.
wanted to talk about that here, but he was like, those are two separate things, which I understood, but those are two whole, conversations that's going to be had. So we're going to actually be doing an event where it will be on Zoom. You can ask questions. We're going to set a date for that within the next few weeks, and you all can get on and ask questions and invite your family, your friends, so that way we can have more of an in-depth conversations. Or is this for family and friends or for agents? Oh, I forgot that
It's for
part.
everybody, like
Okay, that's
your
for
friends,
everybody.
your
Okay,
neighbors, your
okay.
colleagues, your family
Yes,
members. Yes, for everyone.
yes, we want you on here because um, there might be probate, there may not be an option for probate if you talk about estate planning and talk about the benefits of what that looks like. And I think it's just important because people, I hear people are dying every day. So it's happening, and not to make light of it, but
Yes.
people are dying intestate, without a will, without a trust. They don't have anything. And it's like, well, what happens? And if they do go through the process, we got some great information here. And and I will be posting his information on here as well for anybody that wants his information. But if they do the proper planning, imagine not being having to look for a whole bunch of stuff. I'll just say that
That's right.
much. So we're going to talk about that separately. So stay tuned for that. We'll have a flyer and everything where you can go and register and join us in Zoom. And that way we'll have conversations there. Before we end, Sam, is there anything you would like to leave with that? Thanks, Sister Annie.
Well, the thing about probate is it doesn't have to be scary and confusing. With the proper guidance, it actually is manageable. And so that's what we do is we guide folks through the process, and we would love to be of help to anyone that might need it.
Awesome. And I see one of my agents on here, Tori, as well. You all make sure that you get his information, you take it, you hold on to it. You know, this could help a loved one, even if you're not in real estate. And you're like, oh, I heard someone on Kama was talking to someone. Give them my information first, and give them Sam's information so that we can help them through this process to make it as smooth as possible. This is not one of those I'm trying to sell your house type thing, but you have to make sure and understand that this does come with empathy and compassion, and patience. This is not an easy process. It's not going to end. Just do something today and it's done tomorrow. He said a year to 18 months. So
That's
I don't
right.
know if you guys hear my dog whining, but if you do, my apologies.
Yeah.
But at the end of the day, stay educated, stay knowledgeable, and don't be afraid to pick up the phone and ask questions. So I'm Kama Burton with Kama Speaks and CMB Realty Services, where I'm the broker owner. My license number is 014715540. And remember that I'm always here to make your real estate dreams a reality.
Thank you, Kama.
Thank you. I'm going to, and thank you all that's watching. We appreciate it.